We have a couple case studies, and I think understanding these case studies will, right here you can save your clients a fortune in estate taxes if you get them to do this. Case study number 1 is based on our worst case scenario of we're dealing with a $1 million number. What does it take to be in that situation and have an estate tax problem? We have Fred and Wilma here, no relation to anyone famous. And in this case, I put down a couple assets that they have. They have a house, it's probably undervalued at $400,000. It's not hard to have a $400,000 house today. That's a condo. They've got brokerage accounts, a few other things. Fred's got an $800,000 term policy. Wilma's got a $400,000 term policy. Now, Fred dies in 2011. Wilma dies a few years later, 2015. So what are the estate taxes on that? Fred dies first, so we're going to add up all of his assets. And when we add it all up, he had $400,000. He had an $800,000 life insurance policy that he owned, $1.2 million. Now he's over the $1 million amount. Forgot to mention one thing about the estate tax. There's an unlimited marital deduction. You can leave $1 billion to your spouse, and you don't have to pay any estate tax as long as they're a U.S. citizen. The government basically feels we'll take our cut when it goes to the next generation. So, and actually let me make a point here, because there's a planning error which I see, and it's based on prior law. Prior law from a long time ago, like the 70s. But it used to be that there was not a full marital deduction. It was a 50% marital deduction. And because of that, you didn't necessarily want to have all of your life insurance proceeds in your own name. You wanted to have them in your wife's name so that when you died, it wasn't included in your estate and 50% of it went to your wife. Now we have a full marital deduction now, so that if my wife owns this life insurance policy, is there an advantage to this cross ownership? Is there a tax advantage to doing it that way? Because if it's in my estate and I leave it to her, is there a tax on that? There's not one. So there are some disadvantages, though, to doing that, which I'm going to go through, and you'll see in this case in particular. We'll talk about what would happen if Fred didn't own his life insurance policy. If Wilma owned it, you'll see that we'll have a different situation in this case. But on the first death, regardless, whether Fred owns it or not, let's say he owns it, $1.2 million in total assets, full marital deduction, there's no tax on Fred's death. We like that. That's a nice, efficient tax strategy, or result anyways. But now what happens when Wilma dies? Okay. Well, when Wilma dies, she's got $1.2 million she just inherited. She had $400,000 of her own assets, and there's a $400,000 life insurance policy included in her estate. So she's got $2 million in total assets. She dies, leaving her daughter everything. Now, what are the taxes? If she has $2 million and she dies, what are the taxes going to be? You can give $1 million tax-free to their daughter. The second $1 million gets hit with a tax, and it's $435 in that case. That's a pretty big tax on someone that has $2 million in total. Now, Fred had $1 million he could have left to anyone without incurring a tax. And Wilma had $1 million. They should have been able to leave $2 million to their daughter, right? Without incurring $435,000 in taxes. But what happened? Why do we have this huge tax? We have this huge tax because we didn't use Fred's credit. We wasted it. Fred gave everything under the marital deduction. So here is the single biggest bang for your buck. You'll save your clients $435,000 at least. If they've got millions of dollars, and we're talking, a $3.5 million number, you're saving your clients millions of dollars here. What we want to do is we want to preserve Fred's credit. This is doing a huge benefit to your clients if they don't have this in their documents. Scenario number 2, we're going to use what I call a credit shelter trust. You might also hear it called a bypass trust or an AB trust. They're all the same things. They're just different names for the same things. So how does that work? Let's go through the same scenario that we had before. Fred's estate. Fred's got $400,000 in assets, $800,000 in a life insurance policy. He's got $1.2 million total. He leaves those assets, instead of leaving it all to Wilma outright. We're going to put $1 million in a trust for Wilma's benefit, in a credit shelter trust for her benefit. Everything else we give outright to Wilma. Now, what are the taxes on Fred's death? He left $1 million to a trust, but he can leave $1 million to whoever he wants. So there's no tax on that. And then the $200,000 left over went under the marital deduction. Now, what would have happened if Wilma owned that life insurance policy on Fred's life? Could he have put $1 million in a credit shelter trust? No.
He'd only have $400,000.
He'd only have $400,000 because it's not in his estate. So if someone has cross ownership of their life insurance policies, there's no advantage in that situation, but there's a big disadvantage because life insurance proceeds are normally your #1 asset that you look for putting into these trusts. Houses have issues with them. Retirement assets have issues with them. So insurance proceeds are often what you want to use to put into these trusts. So that's a big no-no. Now, if you've got someone who's not a U.S. citizen, you don't have the marital deduction, it makes a lot of sense because they can't use that unlimited marital deduction. But that's the significant minority. Let's assume that Fred does have these assets. He owns his insurance policy. He can fund his credit shelter trust. As we said, the taxes on his death are still zero, which is a good result. Then Wilma dies. Well, Wilma got $200,000 from Fred. She has $1 million in a trust, but she got $200,000 outright. She had her own $400,000, and then there's the insurance of $400,000. So if you add all that up, she's got $1 million in her estate. When she dies, she leaves that $1 million to her daughter, and she can leave $1 million to whoever she wants, and there's no tax there either. So instead of paying $435,000 in taxes, they're paying zero. Now what about the trust? This credit shelter trust, that went to their daughter too. Is there a tax on that when it goes? The answer is no. It passed tax-free. We dealt with it back at Fred's estate. So that is a tremendous result. If you're over $1 million, if this is the law, this makes sense to do. So we definitely want to build the ability to fund one of these into a trust. The last point I wanted to make is you need to be guided through that process. That's the detriment of it. They need to see a professional. And they're making decisions when it's not necessarily the easiest time to make decisions. So that is the downside. But when I weigh those and I discuss those with the clients, overwhelmingly we take the position that it is more beneficial to have the flexibility. And they just know to come in and see a professional, either me. I actually put in my documents, come see myself or another estate planning attorney to help you make the decision.